The Honourable Member David Clendon.
Thank you, Mr Chair. I just want to take a short call, and clearly the Chair is has some enthusiasm to advance the legislation. So this undoubtedly fills a gap. The Greens are supporting this legislation with some reservations, which we've expressed at Select Committee and elsewhere, but it does fill an obvious gap. A person who's suffered assault or attack of some sort at the hands of someone with whom they had a relationship, a domestic relationship or some other form of intimate relationship, can appeal to a protection order, and it seems perverse that there's no similar provision for someone who has been assaulted by someone who does not meet the criteria for a protection order. And undoubtedly this new mechanism does fill that gap. But I would sort of reiterate what Mr Goff has just said, and indeed what Carol Beaumont referred to earlier, that we actually, community safety, the safety of individuals, will never be achieved simply through legislative instruments or statutory provision, or indeed through longer sentences or more jails or more and better policing, not to say that the latter particularly doesn't have a significant role to play. Ultimately, we'll achieve peaceful and safe societies when people have access to education, healthcare, housing, useful and productive employment. The social situation, the social conditions that breed crime need to be dealt with, rather than simply the punitive and the reactive mechanisms that we can deal with through legislation like this. So having said that, we certainly we will support this legislation, albeit recognising it as not a panacea. It's a far short of that. We continue to have some concerns, and unlike some of our Labor colleagues, we have some concerns about the threshold having been reduced from 5 years to 2 years. That seems a significant drop. The original advice from the officials was that the 5-year threshold was set because the policy intention was that the orders should only be available in the most serious and the most violent sexual offending. In part, and I don't entirely accept the notion that it was driven by cost, but in part that the Auditor General's report on compliance pointed to some potential compromising of the Bill of Rights Act, but conceded or acknowledged it was justified given that this order would only be available in response to the most extreme and serious offending as determined by that 5-year sentence. The fact that we're reducing this significantly to 2 years, while I understand the logic of aligning it with the Sentencing Act and other legislation, the point was given, the information was given to us that an increase of this, a change in the threshold could undermine the Attorney-General's conclusion that limitations imposed by the order could be justified under the Bill of Rights Act. And that's not a trivial matter. So the other reflection is that, of course, now that there are many, many more people who will be eligible to apply for these orders, the numbers will undoubtedly increase. The number of these orders could actually become quite significant, not only because of the reducing of the 2-year to a 2-year threshold, but equally because of the other significant change that now enables people to apply for an order immediately post-sentencing, at any time after sentencing. In the heat of the moment, I mean, the trial process, the victim, yes, and often is obliged to some extent relive the very traumatic and unfortunate experience. At that point, that victim is most likely to think, yes, we will apply for one of these orders. Whereas 2-3 years later on, they might be perhaps a more thoughtful approach. Time has passed, perhaps an acknowledgement that offenders actually can be rehabilitated in our prison system on a good day or on a best occasion. So I think the likelihood of quite large numbers of these orders being issued is reasonably something we can reasonably expect. Given that there will be more of these orders, it does concern me that we might eventually come to a similar situation as we have with protection orders, where the efficacy of the protection orders is being questioned, in part because there are a lot of them, and in part because they are not necessarily respected or given the weight either by the enforcement agencies or indeed by the people who they're intended to protect. Excuse me. We have instances where a person protected by an order will willingly allow a breach of it, Mr. Chair.
I call the honourable member David Cleandon.
Thank you, Mr. Chair. And these, if you like, consented breaches lead to more serious approaches later on. The water gets seriously muddied. The police are put into unfortunate situations, and the integrity of the protection orders is compromised very often and makes them less of a protection than they might be. There's also the danger that people become too overly reliant, expect too much of these orders, be the protection order or the new victims orders, and assume that actually they will give them a very real protection. Unfortunately, they cannot be entirely relied on. No document, no statutory device or mechanism ultimately can provide protection. Sometimes it just requires common sense, community and family support, all of those other things. So those two changes, those two substantive changes made through the Select Committee process, the lowering of the threshold and the allowance or the ability now for a order to be applied for and issued at any point after sentencing, we think actually could backfire and ultimately could put us in a less than desirable situation in many in ways it wasn't necessarily to be. I can understand there were problems with not having the orders available until after an offender had been released, because there could then be a gap of time when the person, the victim, could feel threatened or indeed could be threatened before an order could be worked through the system. But we think that immediately after sentencing is probably too early in the piece to allow for this very serious document, this order, to be applied. So with those comments, I do say again, we will support this, but would echo the comments made by other people that it is part of a piecemeal approach. We do look forward to a clean slate, a new beginning in a sense, an assessment of actually how do you get justice, how do you get community safety, and that does require, I think, some more creative and sort of zero-sum thinking than simply tacking on more and more provisions to existing provisions. I had a conversation today, in fact, with a person who had long experience as a lawyer in a provincial town, experience of everything from criminal law, family law, through to tribunals, with the whole gamut of legal action and advice. And he, among others, is seeing people, practitioners are understanding very well that our justice sector in many ways is under stress. We're not providing for a lot of the needs of people as they arrive, that the priorities can be wrong, that we're driven. The system is stressed in many ways, not least of all financially, as has been mentioned. The capacity of our system to deal with people fairly and in a timely fashion is degrading, there's no question of that. The cuts in legal aid, many lawyers now simply cannot afford to function at legal aid rates if indeed people are deemed eligible for it. So we have some very serious problems in the provision of justice that need to be addressed, and certainly piecemeal approaches like this simply won't do it. Thank you, Mr. Chair.
The question is that Clause 1 stand part. Those in favour will please say aye. Aye. The contrary, no. The ayes have it. The question now is that Clause 2 stand part. All those in favour please say aye. Aye. To the contrary, no. The ayes have it. Honourable members, I will report this bill with amendment.
The House is resumed. Mr Chairman.
Mr Speaker. Mr Speaker, the committee has considered further the Companies and Limited Partnerships Amendment Bill and reports it with amendment and divided into the following bills. The Companies Amendment Bill number 4, the Limited Partnership Amendment Bill number 2. The committee, sir, has also considered the Victims' Orders Against Violent Offenders Bill and reports it with amendment. Mr Speaker, I move that the report be adopted.
The question is that the report be adopted. Those of that opinion will say aye. Aye. Contrary, no. The ayes have it. The Companies Amendment Bill number 4 and the Limited Partnerships Amendment Bill number 2 are set down for third reading next sitting day, as is the Victims' Order Against Violent Offenders Bill. Call on Government Order of the Day number 4.
Taxation.